is supposed to do as a law enforcement officer. But that's not what the evidence is going to show he did.
This tyrant police officer went on to murder an innocent man who is desperate for some help. However, this is only the tip of the iceberg of what's coming in this video, as we will show you some of the worst cops ever caught and exposed in the courtroom.
Get your hands up. Get your hands up. That's what he's screaming. That's how he's treating a stranded citizen.
These are the shocking moments when a corrupt cop was finally taken to the cleaners in the courtroom. Massive kudos to these judges for handing out appropriate sentences for these pigs. Particularly the officer in the last case made a devastating mistake. Watch until the end as the atrocities of these evil cops are unfolded.
I hereby sentence Mr. Raja to 25 years in the Department of Corrections. That is as a minimum mandatory, which was required that he serve day for day.
In October 2015, musician Cory Jones was waiting on the side of the road for help after his truck broke down. That is when Officer Newman Raha arrived in plain clothes and did the unthinkable.
All this because Cory Jones, undeniably a black man, was on the side of the road waiting for a tow truck. Now, that's not accurate. It's not because Cory Jones was sitting there waiting for a tow truck. It's because that defendant right there chose to refuse to act like any reasonable law enforcement officer approaching a stranded citizen in help. That is why Cory Jones died that evening.
Poor Jones struck 3 times in total and died on the spot. Noman Raja was on undercover operation during the time and didn't even need to arrive there to intimidate the poor victim.
He recklessly created a situation which could only be expected to result in somebody being seriously injured or killed. And all the evidence is going to show 3 things at the end of this trial. It's going to show that that defendant shot and Cory Jones. It's going to show that he at no time acted like a law enforcement officer. And it's going to show that he is guilty as charged of manslaughter and attempted first-degree murder with a firearm.
The attorney was doing a brilliant job and made sure to expose Raja's corrupt face in front of the whole world.
Cory Jones was doing nothing except waiting for help on the side of the road because his SUV broke down. And one of the few people that should have unquestionably been there to assist him on the side of that road did exactly the opposite. Instead of being Cory Jones' saving grace, he was his angel of death.
It was later revealed that Raja never displayed his badge for Cory Jones, who didn't even know by the end that he had been murdered by a police officer who was actually there swearing to protect the public.
The evidence will show that there's no way Cory Jones knew, even at the time that he was running, fleeing from the back of his vehicle, running into the dark, seeking cover, laying there on the ground, dying, breathing his last breath. No way that he knew that the person that actually shot and killed him was a law enforcement officer. But see, unfortunately for Cory Jones, his bad luck was turning much worse. Because unknown to him, that defendant was on duty. See, he was a police officer at that time of the Palm Beach Gardens Police Department. He was working a detail, a plainclothes detail, where he was supposed to surveil neighborhoods, looking for car burglars. And if he saw anything, he's supposed to call up marked units to come and take care of the issue.
Stay tuned as things were about to get even worse for the defendant, who is having the worst verbal beating of his life.
He cuts right in front of Cory Jones' SUV as his car. He positions himself diagonally, front end to Cory Jones' vehicle, with their bumpers mere feet apart, in an unmarked van with zero indication whatsoever that he's a law enforcement officer at 3 o'clock in the morning on a Saturday turning to Sunday. That's what he chose to do. He runs around the front of that van and immediately becomes confrontational with Cory Jones.
As the attorney exposed Raja's hideous actions, he stood remorseless, showing no emotions whatsoever.
Now, Cory Jones, he's got an expensive job. He goes into not the nicest parts of Delray Beach for his job. So he did what any lawful American can do. He purchased a firearm. He didn't even pull out the badge, which was in his wallet, in his back pocket, to show to Cory Jones. Much less put on that vest that said police, or even had his radio or his gun. There's nothing but an overly aggressive and immediately hostile attitude. You hear it for yourselves. You make the decision. You're the judges of the credibility of everybody, including him, because you will hear from him.
Raja later lied, claiming he had identified himself as a cop and that Cory had tried to attack him. However, Cory had dialed a number during the incident, and the call recording proved to be the officer's downfall, clearly showing that he never identified himself as a police officer.
Yeah, I'm good. Really? That's what he's saying. That's not how an officer talks to a citizen at 3 o'clock in the morning on the side of the road. But that's how he spoke to what he saw with Cory Jones on the side of that road. And when Cory Jones lastly says, yeah, now he starts saying even more hostile. Get your hands up. Get your hands up. That's what he's screaming. That's how he's treating a stranded citizen. Immediately within seconds. That's what he's saying. Profane orders being shouted at a time when a guy is sitting with a broken down car.
It is truly terrifying to even imagine the pain he must have felt. He was gunned down by the one who should have helped him pick cars.
Once again, get your effing hands up. Drop. 3 shots. Cory's running away. He's already retreating behind his vehicle. Physical evidence shows 3 shots. He chose to fire out of that gun because of the way that he acted.
The attorney made groundbreaking points, highlighting how Raja showed no regard for the victim, framing the incident as nothing less than an assassination.
He made a decision to shoot first and ask questions later. That was his decision. But see, this isn't the end of the story. Because now Cory Jones is running for his life. He is running for the cover of darkness. He's thrown down the gun already that he had in his hand that was meant to protect him. And you got 10 seconds. Because he didn't stop shooting. No, he kept shooting. But you got 10 seconds. That doesn't sound like a long time. When you sit there and you look at that clock and you hear those seconds tick away, and you consider that Cory Jones is running for his life after being shot at on the side of the road, that's forever. 10 seconds between the third and the fourth shot.
It also highlights how often police misuse officer safety as a justification, leading to some of the worst atrocities committed in its name.
Finally do what he is supposed to do as a law enforcement officer. But that's not what the evidence is going to show he did. It's going to show his recklessness. His absolute reckless behavior from the start is now changing. Before getting much needed assistance, if he was truly in fear of his life, well, he needs to call a cavalry. 30 seconds. Cory Jones is dead, and it's by the culpable negligence or act of that defendant. And he's going to explain to you, the judge will tell you what culpable negligence means. He's going to say it means a course of conduct showing a reckless disregard for human life or the safety of other persons exposed to its dangerous effects of conscious indifference to the consequences.
Finally, after an emotional and compelling statement from the prosecutor, the jury reached a verdict. Took over 3,000 pages of evidence to prove the officer was in the wrong. The prosecutor's words likely did more damage than any evidence could.
We, the jury, find as follows. As to count 1, we find a defendant guilty of manslaughter while armed with a firearm as charged in the information. As to count 2, we found a defendant guilty of attempted first-degree murder as charged in the information. If you find a defendant guilty of attempted first-degree murder, you must next answer the following questions. Did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant in discharging the firearm actually caused great bodily harm or death to Cory L. Jones? Yes.
Finally, the moment of truth arrived. Evil killer cop was finally sentenced.
On count 1, I hereby sentence him to 25 years in the Department of Corrections. And on count 2, I hereby sentence Mr. Reiser to 25 years in the Department of Corrections. That is as a minimum mandatory, which was required that he serve day for day. Those sentences will run concurrently.
Raja was sentenced to 25 years in prison. He is currently serving his sentence. Additionally, Cory's family filed a lawsuit against City, resulting in a $2 million settlement. This case shows just how easily a police officer can destroy his career and his city. Next, we have another tyrant cop. One wrong decision completely changed the lives of many. On January 18, 2019, Officer Sanchez pulled over Gregory Griffin for a traffic stop. Little did anyone know, soon turned into a tragedy.
Turn off the car.
Wow.
Turn off the car.
Wow.
Sir, turn off the vehicle. Turn off the vehicle, sir. Turn it off. Turn off the car and roll down the window. Open the door. Give me that other unit. Open the window. Open the door.
What's up?
I got a 646. Let me see your hands. Let me see your hands. Hands. Hands on the wheel. Let me see your hands. Let me see your hands.
The female officer was intimidatory and rude from the beginning. Just when things seemed to be a fair bit under control, Griffin made the wrong move.
Hands on the wheel. The car's off. Be advised, the vehicle took off. Thomas in Pennsylvania. Zulu 21 Kilo.
The officer you just saw shooting directly at the fleeing car was Giovanni Crespo, a young Newark police officer who was about to make the biggest mistake of his life. Went on for miles in the streets of Newark as the officers couldn't stop the idiot driver. That is when Officer Crespo made a decision that would continue to haunt him for the rest of his life.
It should be under his leg.
Does anybody fires a weapon here?
No, here, not here.
Delta 91, go.
Crespo fired a total of 8 bullets at the car in 3 intervals. He eventually struck the driver Griffin, killing him on the spot. And one of the bullets also hit the passenger, leaving them critically injured.
Did you shoot?
No, I didn't shoot. Who shot?
Who shot?
Crespo shot. Crespo shot. No, they shot. Crespo shot, and they're gone. Who's there? No, he just pulled off on me. Pennsylvania and Thomas is where I pulled him over. No.
Was that a motor vehicle stop or was that a foot chase?
No, motor vehicle stop. I pulled him over.
Okay. Who you with?
By myself.
Okay.
Everyone on the scene knew that Crespo made a huge blunder. It was only a matter of time before he was charged for the murder.
The car's going down Pennsylvania. It was going way too fast. So
you pulled it over as a 521?
Pulled it over as a traffic stop.
Okay.
Just as a traffic stop. Just because he was going too fast.
Okay.
I got behind him on Pennsylvania and Thomas at the red light. I was waiting for the light to turn green. I thought he was going to pull over right on Pennsylvania. He kept going down Thomas, right on that little curb on Thomas. Pulled over right in front of the church. I got out, told him to turn off the car. He keeps telling me, why do I need to turn off the car? So I'm like, turn off the car, turn off the car. So I go over 646, I got a man with a gun. The Delta unit puts up Moss and his partner. So I tell him he's got a gun, so they're like, Val, get him out. I go to open the door doesn't open, so I go in to open it from the inside, and he takes off.
Where's your car?
503, I was driving 503.
All right, let's see your car.
403. Crespo was eventually claimed to have broken the departmental's policies, and he was charged with aggravated manslaughter, aggravated assault, and official misconduct. The case went to trial, and after a lengthy argument, his mother pleaded to the judge for a lighter sentence.
When I died to Giovanni, I made a promise to his mom that Giovanni was going to be the best that he could be. And she wanted me to raise him the right way, and I did my best.
I would just like to apologize for the event that occurred to the victims, to my family that I put through, everybody that's been going through hard times because of this. I took a chance at a job where it's life or death every day. And the thin blue line really is just the...
Now, if you think this cop did something horrific, this next one took things up a notch.
The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000.
There is nothing more satisfying than watching a corrupt police officer finally face the karma that they deserve. And it gets even better when it all unfolds in a courtroom. Today we will dive into moments where these evil officers were exposed and owned in courts. In August 2017, Euclid police officer Michael Amiott pulled over Richard Hubbard for a minor traffic violation. Amiott escalated the situation, using excessive force and slamming Hubbard's head on the ground repeatedly. Here is the moment he is convicted for his actions.
Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiott guilty of assault, a misdemeanor of the first degree, in violation of section 2903.13A of the Ohio Revised Code, as charged in count 2. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiott guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of section 2921.45A of the Ohio Revised Code, as charged in count 3. We do so render our verdict this 29th day of July, 2022.
Amiott was found guilty on both counts, but shockingly, it took 6 years for the poor victim to get some sort of justice.
Came across to you, but again, that is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
On behalf of the defendant, anything? Yes.
8 months after the jury decided, Amiott was called in for the sentencing. Before announcing anything, the judge allowed the victim, Richard, to have some word.
Richard Hubbard, I appreciate the jury and the court for making the right decision. What Amiott did, something was wrong. he should receive the maximum sentences today. You know, I'm still going through like the suffering with the anxiety, you know, driving, just the temperament, the trauma, and everything. This is a cause for this case. I'm ready to get it over it actually, but just coming back in here, just like bring up everything, you know, and just to see him over there, you know, see all that, just coming back in this court, just like it just brings up everything, like live at the moment. So you know, I hope he gets the maximum sentences today. You know?
Just a short and impactful statement from Richard, and the judge also allowed the evil cop to have some words.
Was a prosecution witness called who testified that I was celebrating in the aftermath of this arrest. They testified that I was high-fiving, fist-bumping, and dapping it up with other officers. There was 5 police cars on East 228th Street that day, all with their dash cameras on and rolling. They all had overlapping fields of view. I can be seen in front of one of those cameras the entire time I was on scene until I was transported to the hospital. Nothing remotely close to what the witness described happened with me or any other officer on the scene. They knew this and put the witness on the stand anyway.
The officer still refused to take responsibility for his actions or have the decency to apologize to Mr. Richard. Deep down, this thug still feels that he did nothing wrong.
I take full responsibility that there was a failure on my behalf to get Mr. Hubbard in custody quickly. The incident was prolonged when I was shot with a taser. During the deployment, I broke my hand, ruptured tendons, and injured my shoulder. When most people see a violent encounter like this, they usually ask, are officers allowed to punch people? And if so, under what circumstances are they allowed to do it? For me, it was important to attempt to educate the jury as I was educated as a police officer. I called every relevant instructor I had to the stand. Taser instructors I had, Department Use of Force instructors, the captain in charge of the Use of Force Committee, my Police Academy Use of Force instructors, and traffic stop instructors.
Amiott was full of himself as he blamed the incident on flawed training that he had received in the past. He claimed to have developed a more effective training system to prevent similar incidents.
I put in every screw, nut, and bolt into the new training area myself. We've never had anything like it before. I worked with one of the defensive tactics instructors to create waivers so we can use the new training area on our own time, using department techniques to get the repetitions we need to not only be more effective on the streets, but to keep suspects and officers safer during these encounters. I want to end by saying I'm not an advocate for or against use of force. Everything I did on that day was based on my training and experience. From here on out, I'll be an advocate for subject control training department-wide going forward, so we can all be at our best when the time comes. I have a deep respect and love for the citizens and this community. I want to do my best to serve them.
After delivering a 9-minute speech, the judge finally took the stage and, before announcing the sentence, had some words for the corrupt cop.
Stood out to me is that the initiation of this incident probably never should have occurred. When you receive that initial radio communication, that initiated this whole thing. And the other thing that sort of stood out to me was that in approaching the vehicle and asking Mr. Hubbard to get out of the vehicle, from my perspective, there was an inability for him to get out of that vehicle without making contact with you. Inability to get out of that vehicle.
The judge also shifted his focus to the victim in this case and urged him to move on with his life and put this traumatic encounter behind him.
I believe the jury got it right. I do. And the court must impose the sentence that the court feels is appropriate in a case like this. And I appreciate If you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also. And not let this incident continue to hover over you. The city compensated you.
Eventually, the sentence was announced, and Amiott still had no sense of remorse or guilt on his face.
The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Mr. Amiott?
Just what count is this in?
As opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
Despite everything, Amiott was only sentenced to 90 days in jail, which was also eventually canceled. In the end, he was placed on 1 year of non-reporting community control and fined $1,000, which really is nothing but a slap on the wrist. While this cop got away with everything, this next cop got the ending he deserved.
To find the defendant, Adam Koy, guilty of murder as he stands charged in count 1 of the indictment.
In December of 2020, Columbus police officer Adam Koy shot and 47-year-old Andre Hill, who was unarmed and did not pose any threat to him. Koy was charged with murder and also fired from the police force. Eventually, in 2024, his case went to trial.
1 count of murder, classified felony. 1 count of felonious assault, felony in the 2nd degree, and 2 counts of dereliction of duty, both misdemeanors in the 2nd degree.
Okay, thank you.
Good afternoon, Your Honor. May it please the court. I am Mark Collins, 006-1207. Adam, can you hear us?
Yes, sir, I can.
Previously, you gave me permission to sign your name to the not guilty form as well as the agreement to have your presence waived and go forward with the video conferencing today, correct?
Absolutely, and thank you.
Adam had pled not guilty to all of the charges against him, and this hearing was aimed to determine the defendant's bail amount.
In addressing the first one, Your Honor, to assure someone's appearance at court, my client has no record in any way, shape, or form, Your Honor. My client voluntarily did a walkthrough of the scene on December 22nd, Your Honor. My client, in addition, gave a voluntary statement to the authorities, and then my client voluntarily met with the BCI agents for about a 2-hour and 15-minute interview. In addition, Your Honor, he was asked to turn himself in an appropriate place and time in which he voluntarily did that. So everything that we've asked of him since December 22nd, Your Honor, he has done. In addition, when he was employed by the Columbus Police Department, he was required to go to a psychologist. He did that as well, Your Honor. In addition, Your Honor, we have his passport if the court would deem that, but it's clear that he's not a flight risk, Your Honor, and that he will appear for every and all court appearances, Your Honor, as so far he's exemplified since.
Adam's defense argued that he posed no threat to society and pushed for a lower bond. However, given the severity of his offense, this was unjustifiable.
The court was guided to look at the nature and circumstances of this individual case. And that's important for this case, Your Honor, because these cases are unique. They're like no other cases that you normally preside over upon arraignments. And that they're unique, Your Honor, because this is not a whodunit or anything of that nature. It's simply whether or not our client was justified in using the force he did, and that will be determined, Your Honor, with a jury. So they're unique, Your Honor, because he's not arrested at the scene. As opposed, on December 22nd, he actually had to walk the BCI agents there. So it's a process that normally happens in these types of cases, Your Honor. He's not a threat, Your Honor. Sometimes it could be a threat to the community. Sometimes the government might ask for a high bond based on potential threat. He's not a threat today, Your Honor. He wasn't a threat today when he met with the agents. He wasn't a threat when he walked them through. He has not been a threat in each and every doctor's appointment he's gone to in his interaction in the community. He has no access to guns, Your Honor. He has been terminated from his employment at the Columbus Police Department. So this unique situation of an on-duty use of force is not likely to happen again. Of course, he doesn't have a prior record, not on bond or anything of that nature. There'll be other factors to look for.
It was later discovered that during his 19 years as a police officer, Adam had 90 citizen complaints against him. It is bizarre to see how someone can remain a police officer after getting so much shtick from the public.
Your Honor, the closest thing this court normally comes to in cases like this is a self-defense case. Various self-defense cases that are currently in the system that we actually represent, Your Honor. We have bonds, people who are out on bond, anywhere from $25,000 to $250,000. And again, the only aspect in this case, Your Honor, is to determine whether or not the force that was used was reasonable or not viewed through the eyes of a reasonable police officer. And ultimately, a jury will determine that. Based on all those factors, Your Honor, we're requesting a reasonable bond. If the court has any other questions for us, I'm happy to answer.
Okay, thank you.
Before the judge announced the final verdict, the prosecutor also explained how the bond amount should be increased.
The difference, the state feels that the difference between those prior goodwill things by Adam Koy and today is that today he is indicted for a felony, multiple felonies. He's indicted for murder, and as you well know, the sentence for murder is a life sentence. So you could imagine that someone who is faced with that may have ideas of not coming to court. So that is the difference between his prior corroboration and where we stand today. As a result, Your Honor, the state is asking for a high bond in this case. Thank you.
The judge set a $3 million bond for the corrupt officer, ensuring some measure of justice.
All right, sir, I'm accepting your not guilty plea. I've considered the arguments by both sides with respect to bond. I am setting bond at $3 million surety or appearance, $20,000 recog, and as a further condition of bond, defendant shall have no contact and stay away from any of the witnesses or addresses identified in the indictment. Also, defendant shall have no contact with other police officers for the request. Thank you.
Good. Would the court consider the $3 million value, or maybe put on the record the components for that make up the $3 million, just so we have that for the next year?
I'm sorry?
Would the court consider lower than the $3 million, or if not, would you put on the record some of the concepts as to why you picked the $3 million?
Yeah, that is based on everything that I've heard. That is the bond that I've set. If you wish to address it with the assigned judge, duty judge, feel free.
This was just the beginning of trouble for the corrupt cop, as weeks later the trial began and the jury delivered their verdict.
Count 3, reckless homicide. We have a general confusion on how to think of this concept and apply the instruction. 1, can you define heedless indifference? The response from the court was heedless indifference is not a legal term, so you must rely on your everyday understanding and usage as to that question on behalf of the state. Before you can find the defendant was committing or attempting to commit felonious assault, you must find beyond a reasonable doubt that the defendant knowingly, 1, caused serious physical harm to Andre Hill, or caused or attempted to cause physical harm to Andre Hill by means of a deadly weapon. In other words, does the knowingly aspect of this statement apply to both aspects of the definition? And the response from the court was yes.
Finally, the verdict is in, bringing a subtle smile to the faces of Andre Hill's family and the court, satisfying to see the cop face justice. He showed no remorse during the proceedings and still seemed to believe that he was the one who was wrong.
Your Honor, we would ask that you delay the enforcement with regards to any sentencing, Your Honor. Specifically, Your Honor, with regards to custody, Your Honor. As the court's well aware, he is in ongoing treatment for cancer. He has a PET scan, I believe, on the 12th, Your Honor. He has multiple appointments that he moved from during the trial till after, Your Honor. There's about, I think, 80 pills that he takes in combinations during the daytime and the nighttime. We would need some time in order to get that supply ready, Your Honor, if the court enforces the custody action. Your Honor, this is a situation in which he is in the middle part of a bone marrow transfer. It has partially taken. It's hopefully going to take, but we would ask that he be remain. He has had no issues while in pretrial services, Your Honor. He has electronic monitoring on. He is not going anywhere, Your Honor.
And as if this wasn't enough, the prosecutor requested that his bond be revoked, ensuring that he would be sent to prison until sentencing was announced.
I'd like to set a sentencing date. The court is not inclined to move forward with sentencing today. I don't know if there are victim impact statements that need to be provided to the court, or at least opportunities for victims to be able to say something to the court. Any documentation with respect to treatments that are scheduled.
Okay.
And then the court also is going to inquire of the jail to see what they're capable of. I've had those conversations previously with the jail for persons that have either been in some sort of treatment or have some kind of injury.
The other thing, Your Honor, we do have medication with us for tonight. Is it okay if we give that to the deputies now for them to administer?
Yeah, I don't want him to be deprived of any of his medications. I don't know who I'm going to need to have a conversation with to make sure that he gets the medications that he's been taking up to this point.
The judge obliged and ensured that this tyrant was heading straight to prison. Here is what Hill's family had to say about the guilty verdict.
Get these sort of verdicts, so this is almost historic to get the verdict like this. Did it come as a surprise at all, or were you fearful that you wouldn't hear the guilty verdict that you wanted to hear?
No, I wasn't fearful because I know what I saw. I know what happened. I know what he did. So, I mean, there was no question in my mind.
What about the FOP president? He literally just said right before you came out, Andre wasn't complying. He was told to put his hands up, to show his hands, and he wasn't compliant. Well, the video shows something different.
The jury spoke different as well.
What's it been like to have to wait 4 years for this moment?
It's been way too long. It's been way too long, but I'm glad that it's over. I mean, it won't bring Andre back, but hopefully it will set a precedent across the board for everyone else. That this is not something that we can tolerate.
Boy, walked back to the back of the courtroom and you knew he was going to jail tonight.
I didn't see him. We left the courtroom by then.
But so knowing that he will be behind bars tonight, what are your thoughts?
I'm glad. I mean, because at least he's still breathing. My brother is gone, so at least he still has his life. I mean, that's really not a fair trade, but it is what it is.
Moving on, this killer cop did the unthinkable and was sentenced to life in prison.
The detective said, side chick, that's his baby mama. And there's a possibility that boy is his son. I'm thinking we're supposed to be the good guys. He's supposed to be watching my back.
It is rare to see a police officer held accountable for their crime, but today we bring you some of the most shocking cases of corrupt officers who did the unthinkable and faced justice in court. Starting with a Border Patrol agent who made the most shocking decision of his life. On April 9th, 2018, Laredo police officers and Border Patrol agents were notified about a double homicide that had occurred in a park. The suspect was another Border Patrol agent, Ronald Burgos, who was in his car when the officer stopped him. It wasn't until 2023 that this case was on trial, and the first responders were telling what happened.
The person that was using that car at the time was supposed to meet a Border Patrol agent at the Father Magnoble Park. Okay. The transmission that came in was the boyfriend's name was Anthony Burgos.
Okay.
When the radio transmission came up for Anthony Burgos, there was only one Border Patrol agent that was at that location with us. I had just seen him. I had never seen this person before. I see him. He's right near the car, and so I wave him over. I say, "Hey, come here." As he's walking up to us, the name says Burgos. So we look at the name. I'm looking at the name as he's coming over, and I'm just like, "Hey, what?" I think this is the person they just called over the radio, but they said Anthony, and I look at the first name and it's an R.
Ronald Burgos had just committed the ultimate blunder, and he was about to be taken to the cleaners by his fellow Border Patrol agents who wouldn't fall for his bluff.
He tells him, "Hey, what's your name, man?" And he says, "Ronald Burgos." And we're looking for Anthony Burgos. And radio transmissions are coming through, and so it's kind of getting a little hectic. Burgos approaches closer to Reyes. I'm walking next to him. I'm the only uniformed officer. So I'm right next to him, and he says, "Hey man, what's your name?" And then Burgos says, "Ronald Burgos Aviles." He only uses his last names. So then Rick's like, "What's your name, dude? Why are you not telling me your name? What's your name?" And he says, "My name's Ronald Burgos Aviles." And he says, You're not telling me your name. Do you have an ID or something?" And he's like, "No, I don't have an ID."
The Border Patrol agent had just arrived after murdering his ex-girlfriend, the mother of his child Griselda Hernandez, and his 1-year-old baby Dominic Hernandez. It was appalling to see how Burgos reacted after doing something as heinous as this.
Yes, so once I took the belt off, I put it behind his unit, and then I patted him down as the unit approached us. So I patted him down. I located a phone on him and a driver's license in his shirt pocket.
Okay, so, and what did you do with those 2 items?
I turned over the driver's license to Detective Reyes, and the cell phone, I put it with his property that I had already taken, which was his Sam Brown. I put it in the back of his truck.
The prosecutor moved forward to show the court the dash cam video of the arrest of the Border Patrol agent. As you can see, the corrupt officer had no remorse on his face.
I'm sorry, brother. 7643-513-851.
What is it that he's doing in that scene?
He's wiping his arms. It looks like he's cleaning something off, or
What was it that he did right before he wiped his arms?
he licked his finger.
Officer Ronald Burgos was desperately wiping his arms and even sucking his fingers, trying to remove any trace of evidence. He had just used a knife to his ex-girlfriend and their young son, with the evidence plainly visible to everyone.
Come on, man. Oh yeah, he could have just told me straight up, man. So don't make him go through it. Embarrassing, big ordeal.
As the trial progressed, witnesses came forward, and amongst them was a key witness, another Border Patrol agent, Francisco Lara, who made a shocking revelation.
I look south and I see the silhouette of the young woman. So I completely forget about Mr. Burgos and I start running towards the victim.
See the victim?
As soon as I see the victim, I approach and I start yelling, like, "Señora, señora, despierta, estás despierta. Ma'am, wake up." Because at this time, all I see is blood. I told my trainee, I call him Schmitty. I like, "Schmitty, is that what I think I'm looking at?" And I see the silhouette and I immediately start running towards her. And that's when I tell him, like, I start yelling at her, "Está despierta, are you awake? Do you have any gloves?" He's like, "No, I do not." So I say, "I don't have any gloves." And I asked my trainee, Schmitty, "Do you have any gloves?" And thankfully, being the great agent that he was, he did have a pair of gloves.
Burgos had devised a strategy, as moments after his ex-wife and son, he ended up calling the cops, claiming that a murder had been committed. Officer Lara explains how he tried to con everyone.
And I immediately check for a pulse. I don't feel a pulse. I look at my fingers and they're covered in blood because I checked her neck area. So I don't feel a pulse. So I immediately see her left wrist. It's facing up. I check her wrist and again I do not feel a pulse. Right away I told Mr. Burgos, "Sir, I think she's 10-7, which means that she's dead." And he's like, "Yeah, it looks that way." So I'm radioing everything into our station and I'm letting him know what I'm seeing. At this time, he's standing there. Not really, the supervisor normally takes control of the situation and radios in everything to the station. Once again, he's quiet. I'm the one relaying everything that I'm seeing to the station. I'm processing everything in, I'm taking it in, and I'm telling them what I'm seeing. And right away, I start telling the camera operator to start scanning the river. I tell him, scan the river, see if you see anybody going back.
Burgos had used his police training, carry out the crime in a bushy area. Poor Griselda ended up having 27 stabs, and baby Dominic had received 2 as well.
Next to the victim, I check her. Mr. Burgos is standing over here too, I guess on the other side of her. So I tell him she's 10-7, which means she's dead. Radio everything in. I told base 2, I think she's dead. They tell me take a step back, trigger the crime scene. So before anything, I told my trainee, go to the gate and open it for the paramedics. He takes off. So before I take a step back, I'm surprised to see so much blood. So I grab my head and I'm like, where is all this blood coming from? I take a step back. At the time he picks her up, I could see the shadow of her face.
Officer Lara, a junior at the crime scene, could not believe his eyes as he watched his senior, Officer Burgos, handle the victim with shocking indifference and remained completely unfazed by the brutality of his action.
I get a phone call from my team leader. My team leader tells me, hey, we already activated the Border Patrol unions, the lawyers for you. Before you make any statements, we already got lawyers. And I'm like, we already made our official statement. He was surprised. He's like, oh, you did? I'm like, yes. He's like, before he hangs up, he's like, just so you know, there's a rumor saying that the dead woman is Burgos' side chick. I'm like, all right, 10-4, let me call you back.
It wasn't until detectives began investigating the murder that Officer Lara realized that the woman was Burgos' ex-girlfriend and the mother of his child. This revelation left him in a deeply emotional and shocked state.
We just heard her.
Going to question answer basis, Mr.
I'm good, sir. Thank you, Your Honor.
That is exactly how everyone in the court felt, and we can only imagine the condition of Griselda's family. It turned out Burgos had committed this horrible act just because he was refusing to pay child support. Finally, after listening to hours of testimonies and getting evidence, the jury reached a verdict.
In cause number 2018 CRA 852D1, in the case of the state of Texas versus Ronald Anthony Burgos Aviles, the jury has returned a unanimous verdict. I'm about to read the verdict of this jury on punishment as to count number 1. Special issue number 1 on count 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal act of violence that would constitute a continuing threat to society. Answer, yes. Signed by the foreperson. Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of the jury.
The jury unanimously decided that Burgos would receive life imprisonment instead of the death penalty. Now, many might argue that the death sentence would have been a more fitting punishment for such a heinous crime.
You heard me announce the verdict of the jury with regard to both counts of this indictment. It is now my job to sentence you in accordance with that indictment, with that verdict. Do you understand that?
Yes, sir.
After being found guilty by this jury of 2 counts of capital murder, and after giving us the verdict that they have just announced, it is my job now to pronounce sentence. As to count 1 of capital murder, and as a result of the sentence of the verdict of the jury, you will be sentenced on count 1 as to capital murder to a term of life without the possibility of parole. As to count 2,
Burgos was immediately transferred to the jail and is guaranteed to die there. This shocking encounter truly left everyone speechless, and it is even more saddening that it took 5 years for justice to be delivered to the poor victim's family. Well, nothing might top the brutality shown by this officer, but this next tyrant made another huge mistake.
Nothing in his hands, and he was shot twice
in 2011, during a routine traffic stop, Officer Osvaldo Villarreal fatally shot an unarmed Benny Herrera. The victim's family filed a lawsuit, but it took 5 years for the case to reach pretrial, as Villarreal's attorney attempted to argue for qualified immunity.
It's a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired, moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
But if we're
backwards.
talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Officer Villarreal had shot the poor suspect only a second after he asked him to take his hands out of his pocket, and sadly, the attorney was defending this monster.
All at one point, his camera was turned on, but he testified.
His camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and now, that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
Shockingly, even the police department cleared Officer Villarreal's conduct, but the judge had another idea.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
The officer was about to face the consequences of his actions as the judge unanimously decided that his qualified immunity should be tossed.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, we take those facts. You're saying that as a matter of law, the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident. Okay. He knew that he had gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole.
On parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The attorney continued to make bizarre and illogical arguments, but the judges swiftly rejected them, firmly believing that the officer should at least stand trial for his actions.
No, so the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor.
The domestic violence incident was over.
Yes, and there...
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so...
It wasn't an ongoing domestic violence incident, but he was warrant out for his arrest, that he had known gang affiliations, and all of those things factor into, am I afraid of this encounter, or do I think that this is going to be a perfectly safe encounter? And everything that they observed, or a lot of the things that they observed, heightened the situation to a point where it was objectively reasonable for the officers. Nobody disputes that, for example, that it wasn't objectively reasonable for the officers to have their guns out. They were going to do a felony stop. Domestic violence under California law is a felony. So they had their guns out. There's some question about whether or not there were other alternatives available. Well, in the split second that decision had to be made, you couldn't put the gun down and pick up a baton. You couldn't put the gun down and pick up a taser, assuming that Officer Villarreal even had a taser. I think there's testimony in the record that he didn't have a taser available to him. He had to make a decision based solely on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here has raised about the fact he didn't have a gun.
I understand. The trial court did.
The plaintiff's attorney stepped forward and presented compelling arguments that further solidified the need for the officer to face trial, strengthening the case against him.
And that the officers perceived a heavy object in that pocket. That's...
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Villarreal opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. He had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available. And
finally, the judges reached a conclusion and gave one last shut-up call to the defense attorney.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were punitive damages, the city would have the option of deciding whether to pay those punitive.
And if you think this cop was bad, you won't believe the actions of this next officer who made the worst mistake.
It's clear to me that you're a remorseless killer. You strangled your wife, you murdered her.
Cops sometimes break the very laws they are sworn to protect, thinking that they will get away with it. But sometimes, karma catches up and they face justice in court. Today we'll be looking at cases where corrupt officers got swift karma in the courtroom.
And he used his badge, and he used his position to satisfy his own desires. He is a cop who turned into a killer.
Starting off with ex-officer Daniel Howard, who was convicted for his wife for 2 years. Daniel claimed it was a suicide, but finally, after an investigation, he was found guilty and brought to trial.
Count 1 is the defendant Daniel C. Howard guilty or not guilty of domestic battery? Guilty. Count 2 is the defendant Daniel C. Howard guilty or not guilty of murder in the first degree? Not guilty. Is the defendant Daniel Howard guilty or not guilty of second-degree murder? Guilty.
Counsel, I'm proposing a sentencing date of May 23rd at 1:30 p.m. That's available. I will order a PSI or a pre-sentence investigation. Mr. Howard, I'll have you talk with your attorney about that. You have the right to participate or not participate in that. You continue to have the right to remain silent. Mr. Howard is remanded into custody. I'll see everyone back May 23rd at 1:30 for sentencing. We will be in recess.
Daniel mercilessly strangled Kendi out of jealousy. Kendi's daughter delivered an emotional statement in the courtroom, leaving a lasting impact.
I struggle with guilt and I struggle with not knowing. I wish I could have convinced her to stay with me instead of going home that night. The fear on her face and in her voice when she told me about how she woke up with him standing over her will never leave me. Nothing will fill the hole he has created. Nothing can fix or undo what he has done. But her name can be free. The thought that he can no longer have control over her name, her memory, and her spirit gives me a sense of peace.
Despite all the proof being against him, Daniel continued to plead innocence, but the judge made sure to take him to the cleaners.
I'm not that monster, I assure you, that people are portraying me.
But what we know, beyond a reasonable doubt, is that you strangled your wife, you murdered her, and then you staged her body in the bathtub, shot her through the mouth, and tried to pass this off as a suicide. That's proven beyond a reasonable doubt. In horrible crimes like this, everybody wants to know why. And often we don't know why, and I can't get inside your brain, but the pretty clear evidence, I agree with the state, is that this was due to jealousy, greed, pride, anger, revenge, some combination of that.
While committing a murder was evil enough, Howard even went on to portray it as a suicide, further proving just how big of a monster he is. It is tough to think that at some point he was a law enforcement officer.
You didn't just, when you killed Kendi, you didn't just kill your wife. You killed a mother, you killed a grandmother, a sister, a daughter, a worker, somebody who brought a lot of life and light to those around her and those she touched. And you snuffed that out because of your own pride, greed, and anger. Despite your efforts at the time to appear emotional and sad and distraught, it's clear to me that you're a remorseless, and I don't say that lightly. I don't say that lightly at all because we don't like to think that anybody would be like that. The lack of remorse, the lack of caring, and just the callous disregard that you had for Kendi and how her death affected those around her. You had these same thoughts. You were talking about allowing people to live through your own self-control and restraint, understanding why people would kill their, quote, old ladies and go to prison. And so you're 58 years old. I don't see a lot of rehabilitation, sadly, in your future. Maybe, perhaps, but that's not a significant mitigating factor in sentencing you.
The disgusting criminal maintained a straight demeanor, showing no remorse for his actions, while the judge continued to grill him.
There is a severe punishment for your wife, and there's no sort of mitigation because the marriage is on the rocks, or the wife was unfaithful, or things like that. There's absolutely no justification here for your wife, and I think it's important that the sentence sends that message as well. I know beyond a reasonable doubt is that you strangled her. asphyxiated your wife. You staged her to be found as if it were suicide. It's an outrageously egregious murder. And of course, all murder is, but this is particularly heinous in my view, having sat through the trial and seen all the evidence.
Soon after, the judge announced the sentence, and from the very beginning, it was clear what fate awaited this brutal individual.
The nature and gravity of the offense standing alone is sufficient to justify a fixed life sentence, and that is what I'm going to impose here. I think Kendi's family deserves to have that closure. The crime is so egregious that I don't think you should be released at any point in the future. And I don't impose that lightly. I have thought long and hard about this, considered all the evidence, considered aggravation and mitigation. There's just so little mitigation here. There's just really none.
The judge remained calm, measured, and compassionate throughout the proceeding. Finally, he read the sentence, providing a sense of justice and comfort to Kendi's family.
You find that a fixed life sentence is appropriate for the count of second degree. On the domestic violence charge, I'll impose 10-year sentence and run it concurrent. I didn't even speak about that. I mean, really, I'm not. I don't mean to give that charge short shrift. The jury found that you were violent and abusive to your wife as well. It's just that, frankly, the killing alone subsumes it all, in my view. And so I'm running that. The domestic violence charge of 10 years will run concurrent with your life sentence.
Howard was sentenced to life with no possibility of parole. It is relieving to know that the troubled man would be spending the rest of his life behind bars. While this dirty cop was taken to the cleaners in the courtroom, this next cop did the unthinkable and was rightly sentenced.
And he used his badge and he used his position to satisfy his own desires. He is a cop who turned into
Former Doralville police officer Miles Bryant was accused of rape and murdering 16-year-old Susana Morales. The disturbing case was tough to establish, but after 7 months after her mysterious death, the officer was charged and ultimately on trial.
He was supposed to serve and protect. Worked as a police officer for the City of Doralville Police Department. Somebody we should hold to a higher standard because of his role in enforcing the law. But he didn't do any of those things. Instead, he abused the law. And he used his badge and he used his position to satisfy his own sexual desires. He is a cop who turned into a killer. His victim, 16-year-old Susana Morales. Susana was in high school.
The 16-year-old was headed home when she was pulled over by this criminal cop. He kidnapped her and ended up murdering her. He then returned to his job in less than 24 hours after committing this heinous act, as Susana's family kept searching for her.
And Susana Morales, on the night of July 26, 2022, her precious life ended because of the defendant's desire to satisfy his own desires. 196 days of no information. 4,704 hours of absolutely no idea where their daughter was, where their sister was. 282,240 minutes. A man named Matthew Gilbert was driving down Highway 316 and pulled off on the side of Highway 316. He saw this trail that is right off the side of Highway 316. At that time, it was February, it was winter, there were no leaves on the trees, and it was pretty obvious like this. But in the summertime, you'll see that this area here is completely wooded.
Matthew Gilbert was off-roading when he discovered Susanna's remains. This crucial discovery set the stage for identifying and capturing the real suspect.
In the middle of the woods on that day, Mr. Gilbert stumbled across human remains. And at that moment, he stopped. You'll hear from him. Still with the black nail polish she had painted on him. She had hair that was dark on the top, with blonde hair on the bottom. They found her hair still there. And you're going to hear very importantly that she was naked. Her body was left there in the woods. They found absolutely not one shred of any fiber, any clothing, any socks, any pants, any shirt, any undergarments.
Despite her body being found in the woods, there was no evidence that would link the to Officer Miles. But just a day later, things took a turn for the worse for the cop.
The first piece of evidence was found the next day, February 7th of 2023. When the Gwinnett County Police Department, which was here that night, they found her body very late in the day. And it became dark very quickly in February. So they secured the scene, they collected what they could, left police officers there to secure the scene, came back the next morning to continue. They located this. This is a Glock 19 9mm handgun, and underneath the barrel is an attached flashlight on this weapon. The gun in the woods near this girl's body. And so they wanted to know who it belonged to. And they found that it was registered to the defendant, Miles Bryant. So they began to do a little more looking. How could his gun end up out there? What they found, and what you'll hear, is that the following morning after she went missing, July 27th of 2022, the defendant called the Gwinnett County Police Department to report that gun stolen. He claimed
Miles's weapon was found at the crime scene, providing undeniable proof of his involvement in the horrific crime. The prosecutor relentlessly grilled him, emphasizing the cruelty and disgrace of his action.
That less than 24 hours after the defendant kidnapped and murdered Susanna Morales, he was back on shift, working as a Doraville Police Department officer. Went into a quick coincidence that his phones are there at the scene with her, that his gun is found at the scene. This is what you're going to hear from his own mouth. And then you're going to hear that Detective Carter asked him repeatedly, was it an accident? Did she fall and hit her head? No. I don't have anything to do with this. She didn't. Was it an overdose? Did she take something? No. It wasn't any of those things. It wasn't any accident. It wasn't anything. That's what you're going to hear from his own mouth. To come back and find the defendant guilty of malice murder, guilty of felony murder, guilty of kidnapping, guilty of criminal attempt to commit rape, and guilty of false report of crime.
Well, as the trial progressed, things were about to go from bad to worse, as the prosecutor interrogated an inmate who was with the defendant in prison, and what he revealed will leave you truly shocked.
Did you get to know him?
I wouldn't say I got to know him, but I mean, I talked to him.
Okay. How regularly would you talk to him?
Every day.
And before we get into the stuff that we're going to talk about, just generally, what kind of stuff would y'all talk about?
Anything, sports, what we did on the street, what we're going to do whenever we get out, if we get out.
What conversation did you have with him about some of the details of what was contained in the discovery?
I don't think I'm not going to get charged for this. They ain't got nothing against me. There's no. It says right here, plain. He says it says right here, plain. There's no blood, no nothing. They can't. They ain't got nothing against me.
So did he indicate to you that he was not going to be linked to
the young girl's body because there was no blood or semen on her?
Yes.
Is that what he said?
He said there's no way this case can be put on me. It doesn't show that I was anywhere around her. It doesn't show no blood, no semen, no nothing.
At this point, Bryant seems guilty as hell, and the inmate was about to expose this nasty criminal even more.
There was a conversation brought up one time. He said, someone could get the death penalty for something like this. I said, no, you gotta do something more brutal than that. And he said, so far they only got me charged with this one. He said, so far I'm only charged with one.
After plenty of hearings, the jury finally reached its verdict, and you will be satisfied that justice was served.
State of Georgia versus Miles Bryant. Indictment number 24B00156-4. Count 1, malice murder. We, the jury, found the defendant guilty. Count 2, felony murder. We, the jury, found the defendant guilty. Count 3, kidnapping. We, the jury, found the defendant guilty. Count 4, criminal attempt to commit rape. We, the jury, found the defendant not guilty. Count 5, false report of a crime. We, the jury, found the defendant guilty. Signed June 12th, 2024 by the foreperson. Anything from the state or the defense?
Your Honor, nothing on behalf of the state.
All right, we would ask that the jury be polled, please, ma'am.
Okay.
The ex-police officer was found guilty of every charge against him instead of just rape. That due to lack of evidence, as the body was found 7 months later. It is even difficult to comprehend how a law enforcement officer would even do something like this.
Mr. Bryant, you now have been convicted of 3 felonies. I want to inform you, you have a right to seek post-judgment relief from your felony convictions by either filing a direct appeal to a higher appellate court or to file a motion for a new trial. You have 30 days from the date I sign and file your sentence with the clerk of court to file a motion for new trial to any and all of the felony charges. Ms. Drake, are you going to file a motion for new trial?
Yes, ma'am, and I did discuss that with my client about that process.
Okay. You also have 4 years from the date of your sentence, from the date your sentence is final, to file a habeas corpus petition on the felonies. I'm going to appoint you an appellate lawyer to handle your case.
Susanna's family must have felt some relief after the jury's verdict. Just days later, the judge called the suspect back for sentencing, delivering yet another powerful and just decision.
Mr. Bryant, do you want to say anything?
Yes, ma'am.
Would you like to say anything? Go ahead.
No, you can speak from there.
I just want to apologize to everybody and to the victim's family. Sorry, that's it.
That's it? Okay. Mr. Bryant, on count 1, malice, I sentence you to life without the possibility of parole. Count 2 and count 3, I believe, vacate as operation of law. Count 5, I sentence you to 12 months, which is the maximum I can, consecutive to your life without the possibility of parole. Thank you. You may go with the deputies.
Bryant rightfully got life in prison, and moments after this, Susanna's family was allowed to have some last words in the courtroom.
Susanna was my little sister. First of all, I just wanted to thank everybody for working on this case. All we ever wanted was... it was justice for what happened to her. So I want to thank you for that. Sorry.
There's nothing to be sorry about.
I just ask that he receives the maximum sentence because no family, no mother, no father. No one deserves to go through this. No one deserves to go through what he went through all these years. These 2 years, I'm sorry.
Jasmine, I'm so sorry you lost your sister. I'm so sorry you lost your sister.
It was heartbreaking to witness as Susanna's sister broke down in tears. The judge showed remarkable compassion, listening to her with full attention, a rare and touching moment in the courtroom.
I just wanted to let you know what our family went through. Seeing my mom devastated every single day, not knowing what could happen to my sister, was very, very disappointing, devastating. Seeing my mom not eat, not be able to sleep. Seeing my mom not wanting to cover herself, thinking that she could be somewhere lost, thinking the worst as the days pass. It's very, very hard not to think anything positive.
The family endured immense pain and trauma because of this predator, and while the verdict may bring some sense of justice, nothing can restore the happiness that was cruelly taken from them.
Had a different theory what could have happened to her. Maybe she got kidnapped. We didn't know anything. Every day was a new series in our mind, like a movie going through our heads. What was happening? What was she going through? Is she being held? Is she being forced to do something? I couldn't even have intimacy with my husband, thinking that she could have been being raped during that time. Seeing my mom lose weight that she never lost over years. She lost weight over 25 pounds during not knowing.
Next, this Border Patrol agent thought he could do whatever he wanted, but he was completely dismantled in the courtroom.
So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
A courtroom can turn out to be the worst place for a corrupt cop, as their corruption gets exposed and they are sentenced to life. Here are some unforgettable moments when these tyrants were tried in court. This Border Patrol agent believed he was untouchable, abusing his authority while on duty. However, things took a turn when a man became furious with his behavior and chose to file a case against him.
When you're at the Border Patrol checkpoint, your duties are to enforce immigration laws and look for terrorists and look for weapons of mass destruction and assist in detecting narcotics. Is that correct?
Yes, sir.
And when you do this, of course, you're following a procedure manual that tells you what to do?
Following policy, sir.
Written policy?
Yes, sir.
You have a copy of that written policy?
No, I do not, sir.
Have you ever seen a copy of that written policy?
That states our authority to conduct immigration checks, or for the checkpoint itself, sir?
For that checkpoint?
No, I have not, sir.
Are you aware of any written guidelines or policies or procedures on how to run that checkpoint?
I am aware that they're out there, sir.
You're aware that they're out there? Let me get this straight. You're testifying right now that you are aware that there are written guidelines and procedures for this checkpoint?
At the border, the cop wrongfully detained a U.S. citizen. When questioned by an attorney, the border agent struggled to defend the unlawful arrest.
Can you state that question again, sir?
Is it your testimony here and now that there are written guidelines and procedures for this checkpoint?
To my knowledge, yes, sir.
Have you seen them?
No, I have not, sir.
But to your knowledge, they exist?
Yes, sir.
Do you recall on June 1st of this year giving a telephonic statement to Mr. Victor?
I do not recall the exact date, but yes, I do recall a telephonic interview, sir.
Do you recall you were in a room with Mr. Katz?
Yes, sir.
I believe there was another attorney in the room who was a representative of the Border Patrol Union?
Yes, sir.
And you were on the telephone to Mr. Victor?
Yes, sir.
And you're aware that that tape recording was being recorded?
Yes, sir.
And were you trying to tell the truth at that time?
Yes, sir.
Do you remember being asked during that statement if you were aware of any written guidelines, policies, and procedures for this checkpoint?
The officer's lies were about to be exposed. A shocking call recording contradicting this previous claim was set to be played in court.
Do I remember that specific question, sir?
Yes, sir.
No, sir.
Do you remember saying that you were not aware of any written guidelines, policies, or procedures?
No, sir.
Would it help to refresh your memory if you heard a tape playing of your voice?
Yes, sir.
Your Honor, if I may? Tell me if this is your voice and if you remember being asked this question and given this answer.
And Your Honor, the state's going to object at this point. Was this noticed as part of your trial exhibit and disclosure?
Actually, Judge, this doesn't need to be noticed because it's impeachment, which is exactly how we're using it right now.
Your Honor, the same standard would apply to both parties. The state would expect everything that be given in notice to both parties.
Judge, the law's well settled in Arizona. If the defense had to give impeachment to the state of the state's witnesses before the state's witnesses testified, it wouldn't be much of impeachment, would it?
Just as the truth was about to be revealed, a shocking twist unfolded. Desperate to defend the cop's attorney objected to the evidence.
We're simply disclosing the audio tape of the interview that the state's witness, where the state's counsel was present throughout the entire interview.
Your Honor,
I have no understanding what possibly could be the objection to this.
Your Honor, may I have a moment? Your Honor, Mr. Victor's quite correct under Rule 613B. The state withdraws its objection.
You may proceed.
Let's ask this question. Do you have any written policies, procedures, or guidelines on how the operation of that particular checkpoint is to be conducted?
No, to my knowledge, no. Is there a citizenship there? If somebody traveling through there, say, comes to our checkpoint, they're U.S. citizens, they're free to go. If they're not U.S. citizens, they say they are not.
Agent Gomez, did you recognize that as your voice?
Yes, sir.
Were you asked the question if there were any policies, procedures, or written policies, procedures, or guidelines for that checkpoint?
Yes, sir.
Was your answer that you were not aware of any?
Yes, sir.
Thank you.
State attorney's objection was swiftly withdrawn, allowing the defense to proceed with the audio playback.
To have your testimony correct that when people pull up and you ask them if you're a U.S. citizen and whether they answer yes or no, then they're on their way?
Yes, sir.
So if someone pulls up and you say, are you a U.S. citizen? And they say no, they're on their way?
No, sir.
Well, which is it? You just said if they say yes or no, they're on their way. But then I asked I asked the question a different way. If they said no and you said they're not on their way, which one is it?
Usually if somebody says no, they already have their immigration documents with them. They present that to me and they're on their way.
And do I have your testimony correct that if you are unable to determine citizenship at the checkpoint, do you usually try to get them to go to secondary?
Yes, sir.
Not all the time?
No, sir.
So sometimes you cannot determine citizenship at the primary, but you just let them go?
No, sir.
And now I'm confused again.
The attorney's skillful questioning quickly exposed the officer's lies. The unprepared agent was no match for the legal expert.
You are unable to determine citizenship at the primary checkpoint. That you usually try to get them to secondary.
Yes, sir.
I did not say always try to get them to secondary. Do you understand my question?
Yes, sir.
Usually means sometimes not, doesn't it?
Yes, sir.
So is it fair to say that sometimes, if you are unable to determine citizenship at the primary checkpoint, that you let them go anyway?
No, sir.
I don't understand again. If someone comes up and you cannot determine citizenship, you say you usually try to get them to secondary. Is that correct?
Yes, sir.
Usually means not always. Is that correct?
Yes, sir.
Like, I usually wear a suit to court, but not always. Do you understand that?
Yes, sir.
Now the attorney turned his attention to the real victim, exposing the officer's true colors in a devastating display of legal skill.
So there are some times that people come up and you are unable to determine citizenship, but you just let them go on their way. Is that correct?
No, sir.
Then what do you do with them?
I try to establish the citizenship there.
And suppose you can't.
And they go to secondary, sir.
So if you are unable to determine citizenship, they always go to secondary.
Yes, sir.
Not usually, but always now.
Yes, sir.
Mr. Anderson was sent to secondary inspection because of the dog alert, is that correct?
It was a combination of both immigration and the canine alert, sir.
Okay. So you're saying part of the reason he was sent to secondary was immigration, not the dog alert?
Yes, sir.
But wasn't the decision made to send him to secondary, wasn't that decision made before he ever got to you?
Yes, sir.
And the decision was made, or you got the signal from Agent Spoonamore?
Correct.
Before any immigration question was asked?
Correct.
And Agent Spoonamore gave you that signal because his dog alerted?
Correct.
The cop's downfall was imminent. He had been discredited twice previously and was now facing the final reckoning.
So the dog decided to send him to secondary?
Correct.
How does the dog determine immigration status?
The canine does not determine citizenship, sir.
So he wasn't sent to secondary for immigration. He was sent to secondary because the dog alerted.
Mr. Anderson never answered my immigration question.
But the decision that he was going to secondary had already been made, correct?
Correct.
He could have pulled up to that primary checkpoint with a passport in his hand, and he was still going to secondary. Is that correct?
Correct.
The lawyer wasn't finished yet. He exposed and defeated the cop with a forceful statement that silenced him.
Is there any better documentation of U.S. citizenship than a U.S. passport?
No, sir.
So it didn't matter what he said, he was going to secondary?
Yes, sir.
Because the dog said so?
Because the canine alerted to the vehicle, sir.
Is a canine trained to alert to people here illegally?
No, sir.
So the dog wasn't alerting for immigration?
The cop was brought down by the lawyer's unwavering dedication to justice and the truth. The illegal stop was exposed and the officer was forced to face the consequences of his actions. This officer's arrogance cost him everything. But wait until you see what this next cop did. It is almost unbelievable.
Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law.
In a shocking turn of events, Indiana State Police uncovered a massive embezzlement scheme involving Clark County Sheriff Jamie Null. The sheriff was charged for stealing more than $5 million from taxpayer funds.
Date of birth? 12/18/70. And Michael Amiott? 52, sir. And the last 4 digits of your social security number? What's your address? 3001 Old Tate Road, Jeffersonville, Indiana. You have a good contact telephone number? Yes, I do. And the drugs include alcohol, sir? No, Your Honor. Do you understand English language? Yes, Your Honor. Let's say something you don't understand. Will you let me know? Yes, Your Honor. Mr. Null, Special Prosecutor Pearl has charged you with 15 counts of criminal conduct. I'll go through them. Count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or about a period of time from November the 9th, 2018, and August the 16th, 2023.
The action was taken quickly when Null's offenses were exposed. With a startling 25 criminal charges, he was immediately removed.
Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain, either directly or indirectly, an interest in or control of property or enterprise contrary to the form of the statute in such case may provide. Count 2, theft as a level 5 felony. It would indicate that pursuant to Indiana Code 35-44.1, you then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A, would indicate that between April the 30th, 2021 and September the 4th, 14, 2022 in Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association.
The investigation took a dramatic turn as authorities discovered evidence connecting Null's wife, Misty, and daughter, Casey, to the embezzlement plan.
On or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation. That being, you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff, public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff. Assigned Walker duties on your personal property, rental properties, father-in-law's property, pole barn, property of Utica Fire Department.
It was a shocking revelation that made people wonder how the sheriff, who was obviously breaking the law, managed to maintain his position for so long.
And count 15. Official misconduct is a level 6 felony would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being Sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being goes to employment as Sheriff of Clark County relating to drug fishing. Mr. Null, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail, treated as a misdemeanor, to 2.5 years in the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
Yes, Your Honor.
Do you understand the potential penalties?
Yes, Your Honor.
As the judge read out the 15 devastating counts against him, Jamie sat calmly. The courtroom was tense as the state attorney argued for his detention without bail.
The next question is, usually do you intend to hire a lawyer, but you obviously have counsel seated with you. I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, severe question and cross-examine those witnesses. You have the right to have witnesses brought into court to testify on your behalf. And at your request, the court will issue subpoenas requiring those individuals to come into court to testify on your behalf or to bring evidence in. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to remain silent. You cannot be required to give any testimony or make any statements against yourself to anyone.
The court defied expectations by granting Jamie bail, a move that would later turn out to be a serious mistake.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Being from the country, or as Mr. Wilder said, Washington County, I keep my shotgun with double aught near me, along with a 45, but the one shotgun for personal protection is appropriate for him to maintain. Will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Null, Mr. Wilder, I know you wanted him released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge, if you so please.
The judge, in a firm and decisive tone, made the decision quite clear, leaving no room for doubt or misinterpretation.
You keep one shotgun only. Try to deceive me, you will not like the consequences. Understand?
Yes, Your Honor.
And then, Judge, the issue of return of all other items, see if we just take them in another hearing.
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
yes, sir.
we'll address in due time.
Thanks, Judge.
Anything else?
No, Your Honor. Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
After police discovered concealed firearms, Jamie broke his bail terms and was taken into custody again. This time, the judge delivered a severe warning.
I told Mr. Null, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
As the judge delivered his sentence, he took a moment to highlight the shocking fall from grace of the former sheriff.
You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Yes, Your Honor.
Or Mr. Boyles, I apologize, Mr. Boyles, your lead. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find it Mr. Ertle's original argument that he was trying to make that I sustained, an officer of the law. Every time I go into court, I hear, I didn't know it was there. I didn't know it was there. I really didn't. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It's your burden. It's your responsibility. And today, the court will enforce that. Take it on.
The 60-day sentence is only the first step. It is unclear how severe his sentence will be because 31 felony charges are still pending. Well, that brings us to the end of this video. Today we witnessed some of the most shocking reactions from corrupt cops facing the ultimate punishment in court. These moments remind us that no one is above the law and that justice must be served to maintain order and accountability. Corruption and abuse of power come with consequences as evidenced by these cases. If you agree with me, please show your support by liking this video and subscribing. Stay updated on more compelling stories like this. Also, if you enjoyed this video, watch this devastating case when an officer discovered a dead body in a garage.
Ooh, buddy.
Oh.
Yeah, there's a body.
Yep. Where?
You can see the legs from the far corner.